Okay, this next part that we're going into is really about. Um, we're going to talk about um, a little bit about. I guess we'll talk a little bit. I don't get into talking about all this history and all this other stuff. Um, read a book or whatever. I don't know. Uh, it's probably a waste of time. So for me, it is at least. Okay, but we are going to talk a little bit about the history. I know I just told you not to, but here we go. Uh, the genesis of the employment practices exposure, if you will. I mean, I'm sure it's always existed and probably worse uh, before one of these seat changes. The seat change was actually the Civil Rights Act of 1964, which promulgated the what we call the Title VII. And a year prior to that, 1963, we had what they call the Equal Pay Act. So I'm not going to get into all the things, Age Discrimination Act or maternity, pregnancy, or warn workers, retraining, whatever, or maybe I will. But I'm trying to try to focus in on like the meat and potatoes of this deal. Okay, American with Disabilities Act, Disability Employees Act. Okay, we'll talk about some of this here and there, but I want to concentrate on this part. Now, this involves what they call protective class of people, and they're the ones that we kind of all have some awareness about race, uh, color. Well, color, race, maybe the same thing. I don't know. Maybe gender, maybe religion, or you understand what I'm talking about. All the six or seven of them that are out there. I'm not going to recite them, but anyway, they're a protected class. Now, where the thing really got teeth, if you will, was in 1991. They amended the Title VII, and what they did was they allowed people to pursue, have jury trials, and to pursue claims against, the uh, like taking it to court and finding negligence and getting paid out, and it actually even included punitive damages. So that kind of transition where uh, people not only were maybe looking at filing a claim, but they were also, whether it's with the EOC or the state or whatever, and we'll talk about that. Um, but they were looking at it in terms of the, uh, uh, what do you call it there? In terms of the, uh, uh, these allegations, these wrongful acts. Okay. Now, uh, there are two ones, and this is uh, we see it in the restaurant quite a bit because I'm gonna go to the side on the restaurant here for a minute or two. Um, and one of them is a Latin term, called quid pro quo, this for that, and that is a problem because uh, it is what we refer to as strict liability. Strict liability means absolute, like if you violate a statute, or in this case, um, they don't have to. There's not about proven negligence. You're just automatically held liable for that thing. And although California is the state that really, um, I'll talk about California separately. You can have your hands full, but I'm gonna talk about an example in Texas, and the Texas deal. When you look at this, you say, okay, an $8 million verdict comes down against Chipotle. And what happened was you had a, I don't know, 14 or 15-year-old girl, younger, like less than 16 or around 16. And as you know, your pretty much all of us, myself at least, and my sisters and whatever, a lot of times your first job is at the the restaurant, and uh, and things go on at restaurants. My previous thing I was talking about, um, you know, uh, this third party exposure related to uh, employees or in an interaction, I guess, between an employee and a non-employee, and uh, that can work in both directions. So I'm pretty old school. My mother was a waitress and had an eighth grade education, and she worked really hard. And I have sisters and stuff. And I would go into a restaurant, and I might be sitting there at the restaurant, and I always treat the people at the restaurant and the young people with the highest level of respect, uh, get to know their name, thank them for everything. But you're going to get people in there every once in a while that are not particularly, in my opinion, particularly nice people. And they could be, harassing the waitress. And I'm not talking about, we use the term restaurants in the business, Hooters or Twin Peaks or any of those places where you say, okay, well, maybe you can expect it, or the so-called gentleman's club where there's uh, based on what I've observed, I've never seen a gentleman in a gentleman's club. But anyway, uh, we should treat these people with the highest level of respect. But it can go both ways. We could be somebody in the off or the restaurant, and we could be, harassing, potentially harassing, or saying things about a customer. He's no good, or his color. I don't like these kind of people, or whatever. Okay, so it can go in both directions. Okay, and we've kind of talked about the third party, and it'll be brought up again, but I used an introductory explanation by showing an office, which was relatively harmless by comparison to or would think to be, to a restaurant, but this is a legitimate issue. So sorry to get off on a tangent, but let me come back to what I was talking about. And what I was talking about is the quid pro quo. Now, this case I was telling you about involved Chipotle. Okay, I do read case law. Okay, I keep up on this because my my opinion is you may think you make decisions or you think the insurance company makes decisions, but ultimately, who has the final say? The courts. Okay, so here's what happened. Young girl is working over at Chipotle's. A supervisor, they make sometimes at some of these restaurants, they make the guy with 10 toes on his feet, the supervisor. And what kind of training does that supervisor have? We'll be going into that, particularly about California law and everything. Okay, so what happens is this person uh, has a consensual relationship, a sexual relationship, obviously, with this younger lady. And so what happens is um, the parents find out. So the parents are very upset. Uh, you would say, well, do they have a case against this guy? Maybe because she was underage or whatever. I'm the civil, criminal. I can't tell you. I don't know anything on that subject. Okay. But this guy takes off to Mexico. Okay. So he's gone with the wind. Okay. But here's who's left holding the bag, Chipotle. And here's the reason why. When you have quid pro quo, this or that, in this case, there wasn't any evidence, let's say, that I know of in reading the case and everything, that he actually said, okay, if you have, sex with me, or you're going to have sex with me if you want to get promoted or earn $2 extra an hour or whatever. This particular situation, for all practical purposes, Chipotle was held strictly liable because it involved their supervisor, and they knew or should have known that there was something going on. Now, I don't know about you, but I'm trying to figure out who gets to control human behavior, especially between males and females, and you know, in a restaurant environment or whatever. But as a you might find it humorous in our day and age, but actually the biggest growth area for sexual harassment is not uh, is male to male, not male to female. Okay, so you know, welcome to the modern world. And actually, I've been ex-military and then also working in the restaurant field as well. I've observed um, some of those behaviors. So neither here nor there. Okay, so the quid pro quo, that's a one-off, essentially a one-off deal. It's not exactly what uh, Chipotle got hit with the $8 million verdict by my definition, but it only takes one of those events and then right off the bat, they're the employer. And I used to run a plaintiff law firm for 2.5 years. And I have a brother-in-law that has law offices all over the state of New York, Hurton and Carr, Coleman, 130 employees, whatever. And I can tell you one thing I know about attorneys for sure. I always say people, I get along great with attorneys as long as they're not looking for me. And I really, when you have a really good attorney that's going to set up your legal things, what you really need to do is to separate things, have them in legal entities. To me, basically, no exception, no reason to have something in your name on that side. And then, of course, we had to use them at the very end. And if we're using them at the very end, it's an EPLI claim or somebody suing you, file suit. You want to make sure that you got a really good attorney because they're all running about 300 or 600 an hour on up. Who knows? But at the end of the day, if I got to pay that kind of money and I feel like I'm getting ripped off for that, for whatever they're doing, make sure you got an attorney that really knows what they're doing. Okay. And, it's not like your next door neighbor, the attorney, or somebody you met at some function. You know, I've had enough experience with attorneys. In fact, I will tell you that me personally, I have two attorneys that I work with. One on my estate planning, which is actually he's a tax attorney as well, which works really well for me since I have a pretty good knowledge of tax and legal and everything. Um, and then my other attorney is more of an entrepreneurial attorney. And so when I had to set certain things up, or, when I've done a real estate transaction or two, I go to that attorney. So they're both good attorneys, but one I use for estate planning and the other one I use, and one or both may do business formations for me. But if I have a real estate matter, I'm going to bring it over to the other attorney. Neither one, in my opinion, is acceptable. Good people, smart people, very talented people, but neither one of them is acceptable for dealing with an employment practices situation. And we'll get into this. Now, the other thing that comes up besides the quid pro quo, which is like, what are you going to do? Because if you can't be there all the time, if you got um especially if you're a franchisee and you have multiple locations, how can you beat it? I don't know, 90 places at the same time. I could barely get to one, much less 90. Okay, so the other thing is another one you get into kind of alongside of it's called a hostile work environment. Now that one is a pattern. It happens over time. There is a thing called the Farragut-Ellerith standard. You might already hear me mention once or twice. Farragut versus the city of Boca Raton and Ellerith versus Burlington Industries. And the gist of those two landmark 1998 Supreme Court decisions was it provides an affirmative defense when you have a program in place that formally notifies people, whether supervisory or your hourly or whatever, that you do not approve or condone, you know, any sort of wrongful acts related to employment practices. Okay, and then uh, to take it a step further, you have to have a system in place for them to report it. And if they do report it, then you have to take appropriate action, response, and communicate that with it, or non-action if it turns out there's nothing, but you know, the old saying, document, document, document. In fact, how we do business in our agency, because I'm ex-claims, regional claims in my 20s, and I ran a plaintiff law firm, and I have 10 professional designations. There's only one way to do things, in my opinion, in life, and that's called doing it the right way. So this is where you had the writing, you had the documentation. We had a claim recently. It's not an employment practice, thankfully, and the suit was filed. I get involved with the claims. I get along great with claims folks because I'm ex-claims. I speak their language. And the claims adjuster brought these comments up. Said, first off, this happened, this claim, if you will, that suit was filed, happened back in December of 2024. So they're asking for all these different things, okay? And I know it's askance from this employment practices, but the way you can tell a really good commercial adjuster, whether they're doing property or liability, the first thing out of their mouth is, when you're a tenant, is I want a copy of the lease agreement. Okay, that tells you what do you respond. Well, what you've signed to in that contract to be responsible for, not what the insurance is going to pay or cover, because that's a contract. It's called privy to contract. That's between you and the landlord, and the insurance company is not involved with that contract. They have their own contract, and that contract is totally separate from if you're a franchisee, your franchise disclosure document, your FDD, and documents that you sign. So don't some people are under the impression that we don't sell everything's covered insurance. In fact, one of the books that I have or read is a very simple title: "Am I covered?" And okay, so you have this, and sorry to digress. You have the quid pro quo, which is strict liability. Pretty much, if it happens, you're on the hook. Okay. Then you have the hostile work environment, and sort of thing. So when you look at those things, those two areas, you say, okay, what am I going to do to address these things? I kind of started touching upon it very lightly about having a set of statements and things in place, employee handbook, initial deal. I'll go into the California stuff in a bit because they've got more onerous requirements, and you better follow them. And to me, there's no downside, because if they give you the free training, and other than a supervisor's got to spend an hour or 2 hours of his life every 2 years or whatever to go through it, I think, try to do, if you've done the best you can, that's all you can do. Okay. So I'm going to leave about this quid pro quo that I've just mentioned, and the workplace environment, and then I'm going to go to the next part of this.